There's nothing you have to apologize for. It's just the way it all plays out sometime. All right, court calls the people of the state of Michigan versus Estrella Rose Jones, case number 2532228FY. Appearances, counsel.
Joanna Carey for the people.
Ethan O'Meara on behalf of Ms. Jones.
Robert Hartel also helping with the jury.
And we are set for a preliminary examination. Is there any resolution in this matter?
Yes, sir.
And what is that?
My understanding is the defendant will plead guilty to aggravated assault. That in count 2, the people will dismiss count 1, felonious assault. She's agreeing to pay restitution in the amount of $100 to the city of Cadillac. Separate misdemeanor case that is being dismissed as a part of this plea agreement. I'm sorry, I don't have that number.
Looks like it's 252342 SM, at least according to the plea sheet.
Yeah, I added that one to this one. Switch.
Should be right, doesn't it?
It's Judge Wiggins. So she's set for 8.
Consent to the judicial waiver if the court was still willing.
And I talked to Mr. Green and I told him that like he's been in contact with us. And he knows like it's going through and everything and he
That's when Mr. Green,
and I told him to call us after to make sure like if this went through or not. And he's been really good at it.
I don't think it will have my disqualification in that case. I don't think we'll have an issue with me taking that plea. The question is whether you want to waive it for me to simply sign the paperwork dismissing it when it's presented. Otherwise, you'll have to wait for Judge Van Alt.
We're totally fine with you doing it.
Okay. If you want to put signatures on that, then. You need some time to talk with her about that, or have you already?
No, I mean, we talked about it a little bit.
So
She
this
understands.
case number is
252342 SM.
who signed the judge's.
I guess I did that. It wasn't meant to be a signature, but its name just went there.
Mr. Hartel, can I get your signature on this as well as a supervising attorney? Just anywhere is fine.
Plaintiff, defendant, okay.
Thank you. Ms. Jones, before we get into the plea taking, have you had ample opportunity to discuss the conflict that I have with the case that Judge Van Alt is handling? Yes. So for whatever reason, I have a conflict with that case. My guess is it probably came up during the time I was the prosecutor, but I don't know that for certain. But by signing this form, you're agreeing to waive that conflict and allow me to handle that case. Are you, I'm sorry, I gotta take this call.
All right.
You may be seated. Sorry about that. So Ms. Jones, what I was saying is for whatever reason, I have that conflict. And you do have the right to not waive the conflict and keep Judge Van Alt on that case. Or by signing this form, you agree to allow that conflict to be waived and allow me to sit as the judge on that case. Is that your understanding? No, it doesn't look like that you have signed this. It looks like counsel has signed it on your behalf. Was that your request? And are you hereby requesting that I act as the judge on that case?
Yes.
All right, and I will go ahead and sign this. We will remove it from Judge Van Alt's docket and place it on my docket. Now, Ms. Jones, have you heard what the attorneys have said the resolution is in this case, which is 2532228FY, the felony that you're charged with, the felonious assault? Have you heard what the plea agreement is in that matter? So it's my understanding you will be pleading guilty to an added count of aggravated assault, which is a 1-year misdemeanor, which means I could put you in jail up to a year, and or fines of $1,000. There is also an agreement that the prosecutor, I say it's an agreement, that the prosecutor will recommend time served plus probation. Is that the agreement, Ms. Carey?
Yes.
Now, Ms. Jones, do you understand that that is your agreement with the prosecutor? I don't have to follow that agreement. If I decide that I'm not going to follow that agreement, you would be able to. No, let me back up. I'm sorry. That's not a sentence agreement. So that is just their recommendation. Their recommendation, their agreement with you is that they're going to recommend to me that would be time served and probation. I'm not required to follow that agreement. Do you understand that? And if I decide that I'm not going to follow that recommendation, you have no recourse. It's not like before where you would be able to withdraw your plea. You don't have that option here. Do you understand that? It's also my understanding that you're agreeing to pay $100 restitution to the city of Cadillac in file number 252342SM, which is the case we just removed from Judge Van Alt's docket.
Yes.
In exchange for all of that, the people will then dismiss that case in its entirety and the 4-year felony of felonious assault in the case that we're here for today. Is that your full understanding of the plea agreement? Have I missed anything?
My apologies.
I don't believe so.
All right. Ms. Carey, did I cover that?
I think so.
All right. Defense, have I covered that?
I believe so, Your Honor.
All right. And Ms. Jones, that's your full understanding of the plea agreement?
Yes.
And you wish to take advantage of that plea agreement?
Yes.
You please raise your right hand as best as you can. Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
So we know back on July 12th of this year, you were on probation in another file, and we've already dealt with that violation or potential violation. Were you on bond in any other file?
No.
Do you remember reading and signing this advice of rights, talked about your rights to an attorney and your rights to a trial?
Yes.
Did you understand those rights?
Yes.
Most importantly, do you understand that by entering a guilty plea today, you'll be giving up the right to have a trial, and you won't have a trial of any kind?
Yes.
Other than the plea agreement today, has anybody promised you anything?
No, sir.
Has anybody threatened you in any way?
No, sir.
And is it your own free choice to plea today?
Yes.
Are counsel aware of any other promises, threats, or inducements that have been not made part of the record?
No.
No, Your Honor.
To Ms. Jones, to the offense that on or about July 12th, 2025, in the city of Cadillac here in Wexford County, that you did commit the offense of aggravated assault, how do you plead?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So what happened back on July 12th of this year? And how did you assault him?
Was I threw something at him?
Hold on. Do you know what you threw at him? How, tell me how you came to throw something at him.
Because he's not the same person I know anymore. He's hurt me in the past and scared me. And I was in fear of my life. He said he was going to kill me.
Counsel, I can't accept the plea. You want some time to regroup?
Yes, Your Honor.
We'll take a recess. Sure. We are back on the record in 2532228FY, the people of the state of Michigan versus Australia Rose Jones. Counsel, where are we at?
if the court is willing, we'd like to attempt any one more time.
Ms. Carey, any objection to
No.
that? Ms. Jones, is that still your desire?
Yes.
And do you need me to go through the terms of the plea agreement again? I am gonna go through these next questions with you, though. Other than the plea agreement, has anybody promised you anything?
No.
Has anybody threatened you?
No.
And is it your own free choice to plead?
Yes.
Are counsel still aware of any other promises, threats, inducements not made part of the record?
No, Your Honor.
Correct.
Or correct, yes.
All right. And then, so Ms. Jones, back on July 12th, 2025, in the city of Cadillac of Wexford County, to the added count of aggravated assault, how do you plead?
Guilty.
So what happened back on July 12th?
I used to live with Austin and he took my headphones and I threw something metal at him.
And why did you throw something metal at him?
Took my headphones and I was scared of him.
Why were you scared of him?
He's lost himself to drugs. And he's hurt me.
He's what?
He lost himself to drugs and he's hurt me before.
How has he hurt you before?
He used to beat me up for the last year now.
Over the last year, you said?
Yes,
And
I haven't talked to him in a while. So
when you went, was it his house you went to?
yes,
And you threw the object, do you know what object it was?
something metal.
Okay, where did you get the object from?
I believe his porch.
All right. And why did you throw it at him?
Because he took my headphones. And I was scared.
Had he done anything to you other than taking your headphones before you threw the object at him? What did he do?
He's hurt me.
Did he hurt you that day?
Yes.
How so?
He punched me.
And where were you at when he punched you?
On his porch.
Was it at that same time period?
Yes.
And how soon to you throwing the object at him was it that he punched you?
Don't try that. I was off my meds. It was a blur.
Was it a matter of seconds or an hour?
Second.
Okay. And just so I've got it right in my head, you confront him about the stolen headphones. He punches you and you throw a metal object at him.
Yeah.
Do you know why he punched you?
No. My only assumption was the drugs.
Okay, but had you said anything to him?
I'm asking for the back.
Did you make any outward attempts to strike him first?
I don't believe so, no.
Did you threaten him in any way?
Don't remember, sorry.
And when you say you were on the porch, is it an enclosed porch or an open porch? Okay,
Like there's a wall, but there's no screens. The only way up it is the stairs, and off of it is the stairs.
okay. How hard did he punch you?
Felt my face crack.
Where did he punch you at?
The temple to my nose.
So just for the record, you were pointing to your right temple down to your nose?
Yes, I tried to dodge it, but he still hit me.
Open or closed fist?
Close.
Counsel, I still don't believe that gets us there.
I
agree. I think we may not be able to accept the plea today. I apologize.
Like that, they told me it was really deep and he had staples.
No, I understand that, but there's times when a defense is there. And at least with what's been presented with me today. I think it's possible that there, I'm not saying that there is a self-defense claim. I'm just saying there's enough of a question of whether or not it was a self-defense for me to accept a guilty plea today. It's nothing that you've done wrong. It's just there's that question there. There's nothing you have to apologize for. It's just the way it all plays out sometimes. So we were set for a preliminary examination, but I note that the plea sheet was signed earlier. Ms. Carey, I'm assuming we're not prepared for prelim today.
Correct.
All right, we will go ahead and we will get this on the docket for next week for a prelim. If something happens that you're able to enter a plea before that, you can do that. Before we adjourn today, is there any other matter we need to discuss?
Yes, Your Honor, I'd like to address bond.
Any objection to that, Ms. Carey? ahead.
Your Honor, the plea agreement today obviously had a recommendation from the prosecution and from, or would have been concurred with myself for probation. Based on that, and I respect that the plea wasn't accepted today. But I think that Ms. Jones has suffered quite a bit while in jail, and in a way that could be remedied by being on bond or being out on bond. She has mental health problems that she mentioned a little bit earlier that she would like to be able to address more properly and can address more properly with the support of her family outside. She's not a flight risk. She lives here. I have no fears that she wouldn't appear in court. And I don't think, based on what the court has, or based on my knowledge, I don't think that any event like this is likely to happen again, especially while she's on bond. So I would ask for a personal recognizance bond. Thank you, Your Honor.
Thank you, Ms. Carey.
But I ask that you continue her current bond pending the preliminary exam in this matter. I don't have her full criminal history with me. As the court knows, she was on probation at this time. At the time that this occurred, she has a juvenile history. I don't have any knowledge of where she will live if she's working. The defense has stated that she has mental health issues and she wants to address those. But I don't know what the plan is for that, or if she was doing it before. She admitted that she was offered medications when this occurred. They say that she has suffered while in jail, but don't say how or provide any support for that. And I understand what Mr. Carnes' agreement was, but unfortunately that didn't go through for whatever reason. So I'm going to ask the court to continue bond as is. Thank you.
Ms. Carey, do you know, is there a juvenile record? Because in my mind, I thought there would have been, but yet nothing shows in lien. So
Judge, I'm sorry, I do not have her lien file, so I can't answer that. I know she was in the system. I don't know if she had consent calendar, but there were files with her.
anything else, Counsel?
Your Honor, the prosecution mentioned that there was not a plan allocated. I'd like to mention that she has a therapist just in general. She's also seeing a PTSD therapist, and she does have support. I don't recall if you remember back to the probation violation hearing, but there was someone here who was, would have been willing to allow her to stay with her. Above that, I do want to mention that Ms. Jones is in high school still, and is attempting to finish that, and is incredibly behind on the summer semester. I don't have anything else to add at this point. I would, if the court would, Ms. Jones would like to make a statement at some point.
Are you comfortable with that?
Yeah, I'm not with that.
Ms. Jones, I'm going to caution you about saying anything about the case. I don't want you to say anything about the case or the allegations, okay? I'll also remind you that you have protections under your other case, so I don't want you to talk about that one either, okay? What is it you'd like me to know?
That the jail does not help me, my mental health. I have had multiple episodes in there, and I've already heard myself multiple times in there. They don't help me whatsoever, and I really need my outside help. Like my regular therapist, my intensive therapy. I was supposed to get me medication. I'm very behind on school. I wanted to get a new job, get a car, finish my schooling, and go to college. I learned my lesson with that. It's like, I don't
Your
wanna-
what up, sorry?
I learned my lesson. I don't want to end up in the jail. Talk to all the girls in there. I don't want to end up like them. I'm not even from here. Just got dropped off here.
But you've been here for quite a while.
I mean, yeah, I have a new adopted family, Master Street. But when I was 15 or 16, my dad just dropped me off at a pizza place here. And the school has failed me here, so I'm now doing Harrison online school. But I can only do that at home. I think I can't do it in the jail. I really know I'm 19, but I'm behind, a couple years behind, and I would like to catch up and live peacefully and happily and get a better chance at life. I don't want to end up with people here.
Well, Ms. Jones, well, since this is a bond motion, we'll go through the requirements of bond. And some of the things the court is to look at pursuant to MCR 6.106 is the defendant's prior criminal record, including juvenile offenses. As we've already discussed, there is no official record regarding juvenile offenses. Record of appearance or non-appearance at court proceedings or flight to avoid prosecution. I've not had anything in that regard. A history of substance abuse or addiction, nothing's been presented to the court. Mental health, including character and reputation for, I'm sorry, mental condition, including character, reputation for dangerousness. What I do have is a case that the defendant's on probation for, in which it was alleged that she beat up a 14-year-old girl for statements made by somebody else's, about somebody else's deceased mother. Then I have this seriousness of the offense, the presence of any absence of threats or possibility of conviction or likely sentence. At least the defendant is charged with a felonious assault, which is a 4-year felony. Now, I do realize that there's a possibility of a self-defense claim, but what the court is left with is only hearing one side of the story, so to speak. I do remember in the probation violation file, reading a police report and not finding there enough evidence for a probation violation. But again, that was more so because no witnesses had been presented to the court to offset a self-defense claim. If we have a preliminary examination, I suspect there will be witnesses that will testify, and I'm suspecting likely would testify that there wasn't a self-defense claim. Employment status, the defendant was in between jobs at the time that this case had picked up. Obviously has not been able to get a job since. Responsible members of the community vouch and monitor for the defendant. I do remember other persons here in the multiple times that we've been here in the past. I don't believe they're here today. But what does stand out is at least the address that you gave me on Mauser Street is the address that you gave me at the time of arraignment and was the address at the time that these charges arose. Defendant's ties to the community, while her ties to the community are rather transient, meaning she doesn't necessarily, at least in the past, have a stable tie to the community. I do realize she has had ties to the community for quite a while. And any other facts or risks, non-appearance, danger to the public, etc. It is the that one that the court has some concerns with. As I had said, you were on probation in another case, and the allegations of that case, I've already stated what they are. And now, if I recall correctly, it was about a month later, you've picked up the new charge and elevated from an assault to assault with a dangerous weapon or felonious assault. It does appear that the defendant, at least allegedly, has a violent streak in her. And so I do find that she is a risk to the public. But I also do realize that there is a potential for based on what I've read in the police report, and as outlined by Ms. Jones today, while trying to take the plea, there could possibly be a defense. I'm not saying that there is, I'm just saying that there possibly could be. Bond was set previously at $10,000 cash or surety because I did find her a threat. I'd also ordered there be no contact with the victim in this case, Austin Elkins. I do realize that in the state that Ms. Jones finds herself in, is the court ordering any bond is essentially a revocation of bond. However, I do find that she is still a threat. She went to somebody's house, at least allegedly, to get her earphones and wound up throwing a metal object at that person. I am going to reduce bond to a $5,000 cash surety with the same conditions. But I do believe there is an additional co-defendant that I was not aware of at the time that this arraignment had taken place. So I am going to add another condition that the defendant not have any contact with, what's the first name? With,
Your Honor, if I may, I do apologize, just so the court's aware, that is the gentleman who's here for moral support.
I'm aware of that, but
Okay.
he's also a co-defendant in the case.
Yes, Your Honor.
So I'm going to order that there be a no contact with an Ethan McPherson as well. All other conditions remain. I will say this, counsel, if you're able to give me proof of doctor's appointments, proof that there's ongoing counseling, proof of medication, I'm not going to foreclose not hearing this again. But based as what's been presented to me today, that's where we're at. Okay. Anything else, Ms. Carey?
No, thank you.
Ms. Ejimera?
No, thank you, Your Honor.
Hey, thanks for watching. Please do let us know in the comments what you thought of this video. If you'd like to support what we do here, the best way to do it is to pick up some of our merch. You can find it at courtroomfiles.com.